be internationally wrongful if committed by that state. In its commentary, the ILC makes it clear that the state which assists the perpetrator of the wrongful act must intend to facilitate the wrongful conduct, and the assisted state effectively engages in such conduct. The assisting state incurs responsibility even if such assistance is not essential to the performance of the wrongful act. It is sufficient if it, quote, contributed significantly to that act. The assisting state must therefore be aware of the fact that Israel is violating international law and that the assistance given to Israel was intended to facilitate such violations. In casu, the EU and its member states could not have been unaware that some form of assistance to Israel contributed or would perforce have contribution to certain wrongful acts committed by Israel. This is applicable to following. First, export of military equipment to a state that has maintained an illegal occupation for more than 40 years. Next, imports of produce from settlements located in occupied territories and no real control by the customs authorities of EU member states of the origin of such produce, save in exceptional circumstances, whereas the exception should become the rule. And next, third, evidence of a report repressed in 2005 and repeated internal reports by EU officials to EU bodies listing violations accurately only to be ignored by those bodies. In both cases, this conduct contributed significantly to the wrongful acts committed by Israel, even if they did not directly cause such acts, and it is reasonable to assume that the EU could not possibly have been aware of this. In these cases, the EU may be held to have been complicit in the wrongful act committed by Israel and hence to incur responsibility. The participation of the settlements in European research programs, the failure of the EU to complain during the caste-led onslaught operation about the destruction by Israel of infrastructure that the EU had funded in Gaza, and the proposed upgrading of bilateral relations between the EU and Israel are characterized by a number of experts as assistance to Israel in its alleged violations of international law. The ILC considers that one must, in cases of this kind, carefully examine whether a state accused of wrongful assistance was aware that it was facilitating the commission of the wrongful act. According to the ILC, to quote, where the allegation is that the assistance of a state has facilitated human rights abuses by another state, the particular circumstances of each case must be carefully examined to determine whether the abiding state, by its aid, was aware of and intended to facilitate the commission of the internationally wrongful conduct. ILC Report 2001. Even if the acts of the EU and its member states do not contribute directly to the violations of international law committed by Israel, they provide a form of security for Israel's policy and encourage it to violate international law because they cast the EU and its member states in the role of approving spectators, as the ICTY put it, to quote, "While any spectator can be said to be encouraging a spectacle, an audience being a necessary element of a spectacle, the spectator in these cases," German cases being cited by that chamber, "was only found to be complicit if its status was such that its presence had a significant legitimizing or encouraging effect on the principles," and the references are provided. As noted by an expert, the silence of the EU and its member states seems like tacit approval or a sign of acceptance of violations of international law by Israel, as it is inconceivable that the EU and its member states are unaware of the violations of international law being committed by Israel. The RTP concludes that the acts in question constitute wrongful assistance to Israel within the meaning of aforementioned Article 16 of the ILC Draft Articles on State Responsibility. At this stage of proceedings, the RTP calls on as follows. 1. The EU and its member states to fulfill its obligations forthwith by rectifying the breaches specified in Section C and the failures specified in Section D, which I've read. Secondly, the EU in particular to implement the EU Parliament resolution requiring the suspension of the EU-Israel Association Agreement, and thereby putting an end to the impunity that Israel has benefited from until now. 3. EU member states to implement the recommendation at paragraph 1975A of the UN fact-finding mission report on the Gaza conflict, the Goldstone Report, regarding the collection of evidence and the exercise of UJ against Israeli and Palestinian suspects, and 4, EU member states to repeal any requirements in any member states that a suspect must be a resident of that member state or of any impediments to the compliance with the duty to prosecute or extradite for trial all suspected war criminals sought out by member states. 5, EU member states to ensure that UJ laws and procedures are made as effective as possible in practice, including through coordination and the implementation of agreements on the mutual cooperation of states on criminal matters through the EU contact points on cross-border and international crime, Europol and Interpol, and so on. 6, EU member states to make no regressive changes that would blunt the effect of existing UJ laws so as to ensure that no EU member state becomes a safe haven for suspected war criminals. 7, the parliaments of Austria, France, Greece and Italy to pass laws providing the penal legislation required by Article 146 4GC to enable UJ to be exercised in those countries. 8, individuals. This is very important. It comes to civil society and what people can do.